Well, Donald Trump Jr. is set to take the witness stand once again in the civil fraud trial against his father, the Trump family, and their company. This time, he'll be acting as a witness for the defense while being questioned by the plaintiffs 2 weeks ago. Trump's oldest son testified that he never worked on his father's financial statements and left the accounting to others. The former president and his children deny any wrongdoing.
For more on this, let's bring in CBS News legal contributor Jessica Levinson. So, Jessica, it's good to see you. How does Trump Jr.'s testimony set the stage for the defense?
I think what he does is say, not it. We weren't key to these transactions. And what he's going to say is on basically the front end, we relied on the accountants and the lawyers. So when it came to preparing these statements, we weren't integral. Even though we signed off, we were kind of deferring to other people. And then he's going to say, once the banks and the lenders got that information, they really didn't rely on it that heavily because of the disclaimers. They did their own due diligence. We weren't a key link in any part of those transactions that you say harmed the lenders or harmed the banks. I think we're going to hear more of what we heard when he was on the stand for the prosecution.
Actually, can you elaborate a little bit more about that, about the possible defense here? Because I have to admit, when I heard about what the argument was, I kind of saw the counter argument, which is who's harmed here? These big banks? Well, they didn't complain.
They didn't complain. And in fact, they made a lot of money. And so what I think it's important for people to know is that there is one of the statutes that the New York Attorney General Letitia James charged under here does not require that there be the typical type of financial harm that we're used to. So even though that certainly is the argument, I think it's a better argument for the jury, if there were a jury, who would kind of say, oh, well, maybe no harm, no foul. The other argument that Letitia James is making outside of, look at this statute, it's very expansive, it doesn't require the type of financial harm you would typically see, is that actually Donald Trump and the Trump organization got a lot of ill-gotten gains. And so they got loans and they got favorable treatment that somebody else would have gotten. So yes, the banks made money, but that wasn't Donald Trump's money and the Trump organization's money to make in the first place. Somebody else lost out on that opportunity.
So did the state get what they wanted from the prosecution phase of the trial?
I think yes and no. Their best witness, who specifically testified, Donald Trump told me to basically cook the books. He told me to inflate the value of these properties in order to get favorable loans, in order to get better insurance deals. That was Michael Cohen. And he kind of backtracked when he actually was put on cross-examination. And he said, well, Donald Trump speaks in code. So he didn't specifically tell me to do that, but I understood what he meant. But there are some flaws in the prosecution's case, or I should say some weaknesses on the remaining counts. We all know that the judge in this case granted summary judgment on one of the 7 counts before trial began, saying these documents were prepared and they were fraudulent. But on the other counts, I do think if we look at weaknesses, there is a weakness in trying to directly tie the former president to these fraudulent statements.
In another one of Trump's legal battles, attorneys for the former president are now co-signing a request from members of the media to allow cameras in the courtroom. And this is for his Washington-based election interference case. I guess it's interesting,
yeah.
but not surprised. As much as he sort of bad mouths the media,
he loves it.
Fake media, all that stuff, he loves it. So I guess it's not surprising that they're on the same side here. What's the legality surrounding that request?
It's an uphill battle because of the federal rules of procedure. And so certainly in the state criminal case, in the Georgia case, everybody has said this will be televised. I think what it says to me isn't so much a legal argument, it's a political argument where the former president clearly thinks that he is arguing to a broader audience when it comes to these trials. He's arguing to his potential donors and his potential voters, even more important. And he wants everybody to see his performance and the performance of his lawyers. Again, in terms of the legality, it's uphill because of what we all know, which is that what happens in federal courtrooms typically is not televised for a reason. It goes against their rules of procedure.
Jessica Levinson, thank you.
Thank you.